Acting President. The current matter before the court is the case between Open Media as applicants against the Republic of Media respondents. Each side has 45 minutes to present their case, and the court now calls for the first counsel of the applicants to come forward. Please be seated.
Yes.
Mr. President, Your Excellencies, it is an honour to appear before this court today. My name is Chin, spelled C-H-I-N, and I appear with my co-agent, Morrison, spelled M-O-R-R-I-S-O-N. We appear on behalf of the applicant. In addressing this court, I will be speaking for 22 minutes, my co-agent for 22 minutes, and we reserve 1 minute for rebuttal. In establishing the case for the applicant and establishing that the Internet Responsibility Act should be found invalid and that the First Family Privacy Act should be similarly found invalid as it is not consistent with the rights under the Universal Declaration, I will be making submissions pertaining to Orders 1 and 2, concerning firstly, the collection and verification requirements under the Internet Responsibility Act, and secondly, the requirement to disclose historical location information, following information, and identification information. My co-agent will be dealing with Orders 3 and Orders 4, pertaining to, firstly, the requirement to disclose real-time location data for users of the MLM forum, and finally, dealing with the operation of the First Family Privacy Act. Your Excellencies, turning to the first submission, it is the contention of the applicant here that the requirement to collect and verify identification data is in violation of Article 19 of the Universal Declaration, the freedom of expression. And we say this for one primary reason, the reason being that it breaches the principle of anonymity. The principle of anonymity is founded in the cases which lie in the US Supreme Court, namely the case of McIntyre and Ohio, which has affirmed the case of Talley in California. In those cases, Your Excellencies, it was decided that the principle or the ability to remain anonymous is a critical aspect of the freedom of expression. And it finds its basis, in essence, because the effective exercise of the freedom of expression must be as such that it can be made without fear of reprisal. As was stated in the case of McIntyre, anonymity acts as a shield from the tyranny of the majority, and it protects individuals from the retaliation and their ideas from suppression. In application to the current facts, we would submit to this court that the Mondarian people, who are of the smaller ethnicity in this ethnic conflict, who have been the subject of alleged military improprieties at the hands of the possibly the Durian people and possibly at the activities of the militaries themselves, that being in this unique position, their views and their ability to express their dissenting views has been compromised. Your Excellencies, we would submit to this court that the fact that anonymity cannot be satisfied leads to a breach via the use of the chilling effect. And where citizens who believe or are subject to the possibility that their personal information or whereabouts can be easily tracked and monitored may abstain from engaging in civic discussion. And it is on this basis that we would submit that the requirement to collect and verify identification information represents a breach of Article 19.
Now, are you saying that the collection of this information can never be justified, whatever the demands of public order and the rights of other people?
No, Mr. President. What we would submit in this case, and it may be pertinent to then turn to this issue, is the measures of the proportionality of the operation of the Act. And this turns to the third limb of the limitations test, which are outlined in the European Court, namely whether the limitation is necessary in a democratic society. Mr. President, it would be our submission in this regard, with reference to proportionality, that there are three reasons why the law in operation is not proportionate. First, the law which applies is absolute and discretionary. It does not make a distinction between users of other internet content hosts. And more generally, with reference to open media, it does not target the forums of concern, but applies broadly to the platform itself. Second, we would submit to this court that the restriction on all anonymous speech, especially speech which we would regard on the basis of the facts, specifically in paragraph 11, a speech which is representative of political expression, in that it outlines the military acting in its official capacity and outlines the activities, their alleged military improprieties, and the detaining of citizens of Mondahian race. These are clearly issues of political concern and of political expression in the current climate in the state of Bamidia. The final reason which we submit to this court that the law should be seen as disproportionate is that, subject to clarification 13, the Internet Responsibility Act has no sunset clause and is permanent in its existence in the state of Bamidia. More so, the government intends for the legislation to operate indefinitely, and in doing so, the violation of Article 19 is similarly affected in the sense that it will apply to all future periods. We do acknowledge as the applicant that there is a security threat in this case, that there are instances of bombings and the death of civilians. However, the fundamental submission in which we rest this case in order 1 on is the fact that the law can be seen for these three reasons as being so broad, being so absolute, being so discretionary, that a finding of proportionality would not be the correct one for this court to make. Your Excellencies, if I could take this court back one step and address this second limb of that test, whether the limitation pursues a legitimate aim. It is the submission of the applicant that in the present circumstances, the facts do not support a finding that the Internet Responsibility Act targets a legitimate aim. What has been found in the case of the Human Rights Committee in the Shin and the Republic of Korea is that there must be a direct and immediate connection. And if we turn to the facts of the case today, specifically in paragraph 12, the government acknowledges that there is no direct causal, but there is no direct proof of a link between open media and the bombing attacks which have been occurring. Moreover, in support of this submission, we would ask this court to note under paragraph 11 the activities which are in fact taking place in the forums of open media. Namely, that the users are documenting the military questioning and the detaining of persons. They are noting the military presence in certain locations, and they are providing discourse on military improprieties. All elements which we would submit as the applicant demonstrate that the focus of the Internet Responsibility Act does not address the concerns of national security and the prevention of such acts.
Counsel, can I ask you to help me with a problem that seems to arise from what you're saying? The proportionality judgment that it seems we may need to draw is, according to what you've said so far, between the impact of the act in chilling freedom of expression by exposing persons to the threat of reprisals if they lose anonymity. That's on one side of the balance. And on the other side, purportedly, is the danger to national security. Now, you've pointed out that there's no direct proof of the threat to national security, and you're saying that this legislation does not even pursue a legitimate aim, so we don't even get anything into that side of the balance. But on the one hand, surely there's an evident risk to national security. So I want to ask you whether it's legitimate, potentially legitimate, for the government without direct proof to respond to a risk. And on the other side, really I see nothing in the facts before us to support your suggestion, if that's what it is, that the people expressing themselves will be subject to reprisals if they lose anonymity. Where's the factual basis for that side of this balance that we're going to need to draw, according to your argument so far?
Yes, Your Excellency. Dealing with that first issue, namely, we would submit that there is a national security threat. We don't contest that point. What we would submit is that the facts, as far as we understand them in this case, demonstrate that the Internet Responsibility Act does not address this national security threat. That there can be made no link between the actions of the users of open media and the national security threat itself. And Your Excellencies, turning to that second part of
So you're saying that there is no risk that that open media will enhance the danger to national security that arises from the opposition movement, the MLM. Is that what you're saying?
In essence, Your Excellency, that is our point in one regard. Although our alternative submission, should this court decide otherwise, is that the law in the Internet Responsibility Act is not proportionate in its response if it is in fact targeting that national security threat. Thank you, Your Excellency.
If you allow me, I have another question.
Certainly, Your Excellency.
I see that you're coming to this court on behalf of open media, but also on its users. Could you please, in your presentation, specify further what are the rights allegedly violated as concerns open media and as concerns its users?
Apologies, Your Excellency, I didn't hear the end of that question.
You appear on behalf both of open media and its users. Could you please specify in what manner their specific rights were affected? Because open media and its users may have different rights affected by the law, and I would be interested to know more about how you see them affected and in what manner violated, if so.
Yes, Your Excellency. With regards to the orders which I'm dealing with, namely Orders 1 and 2, it is in fact the submission that it's the rights of the users of open media, in Order 1 specifically, who have their freedom of expression are violated by the actions of the respondent. With regards to Orders 2, the requirement to disclose the location information, the tracking information, and the identity information. Again, it's the rights of the users and their right to privacy which have been violated. In addressing the orders of my co-agent very briefly, in Orders 3, it is a similar violation of individuals' rights. Yes, Your Excellency.
Go ahead.
Apologies. And in Order 4, Your Excellencies, it is the right of, in this case, the first family and their rights under arguably privacy concerns or security concerns against the rights of the public interest, or the public interest in that case, which is slightly different. However, Your Excellencies, if I could take this court's attention back to Order 1 and deal quickly with an argument which may be raised by the respondent regarding the margin of appreciation. The applicant does acknowledge that states do exercise a margin of appreciation in which measures they choose to address and how they address that aim. However, what should be noted by this court is that when the right in question is in fact important, the European Court has accorded the states a more limited margin of appreciation. The exercise of the freedom of expression, especially when it concerns matters of political interest, which we submit exist presently, is such a fundamental right. And this has been affirmed in the case or in the decision by the Human Rights Committee in Aduam et al. And Togo. We would submit to this court that accordingly, the right to freedom of political expression and its crucialness in the operation of a democratic society should lead this court to find that there is a very narrow margin of appreciation in this case, and when combined with the disproportionate factors which exist, would lead this court to find that the law is in fact a violation and not a justifiable derogation.
It seems to me that your entire argument rests on recognition of the user's right to anonymous speech. But why should we assume that they have an expectation of anonymity here, where the only reason that their information is kept confidential is because open media requires them to keep it confidential through the registration process?
Your Excellency, that delves into, in some parts, Order 2, and we'll address it in this regard. The disclosure of identification information, as has been outlined in the jurisprudence of the US Supreme Court, has stated quite clearly that the provision of that information to the government does in fact have a chilling effect on the freedom of expression. Now, we would submit that the present circumstances and such disclosure would correspondingly breach that freedom of expression.
But is there any evidence in the first instance that the users themselves have an expectation of anonymity at the time that they're signing up? Because I take note of the fact that none of the users have challenged this law on their own behalf.
Yes, Your Excellency. Dealing with that expectation of privacy issue, which I believe comes from the US Supreme Court, what we would submit in this case is that the internet represents a distinct medium. It's a different medium to the cases which apply that expectation of privacy, for instance, in the cases of Smith and Maryland. We would submit in this case specifically that the data requested, which is in addition to the identification data which can be disclosed, that represents content, or content which discloses in some degree the communications of the users. And on that basis, we would submit that there is a reasonable expectation of privacy which should be protected in this case. Your Excellencies, maybe if I turn...
So does our, in order to rule for you then, and does that mean that we have to find as a matter of law that all users of sites where there is an anonymous registration requirement are exercising their right to anonymous speech?
Your Excellency, I'm not quite clear where that question is directed at. If you could maybe repeat it.
Well, without any evidence, without any direct evidence that the users themselves are asserting their rights to anonymous speech, does that mean that we have to make that assumption in all cases where there is a registration